morning all. I am Professor K.D. Raju, Professor of Law, Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. In this NPTEL course, Intellectual Property Rights and Competition Law, this week we are going to discuss the concept of intellectual property law and different categories of intellectual property rights. We know that the concept of intellectual property law is very simple. It is actually says that it is the creation of human mind or an incentive for innovation, or it is a statutory right given by the government to the innovator or the inventor, or we can say that it is the fruits of creativity or it is an incentive given to the inventor by the government for a limited period of time. At the same time, we can see the different categories of intellectual property law, and in this particular week we are going to deal with patents, trademarks, copyrights, geographical indications, designs, integrated circuits and trade secrets. These are the 7 categories of intellectual property rights described in the one of the WTO agreement dealing with intellectual property law, that is the trade related aspects of intellectual property law. And you can see in this particular picture what they are saying. They says, all I asked was, can I patent my copyrighted trademark? So, these fellows do not understand what is a copyright, what is a trademark, what is a patent. So, in most of the cases the people have this misconception, what is a patent, what is a trademark, or they could not find any distinction between the different categories of intellectual property law. So, if you are not able to understand, yes, definitely you require this class. So, this week we will discuss the categories of intellectual property law. The IP philosophy, which we already talked about, the incentive for innovators. The entire regime of intellectual property law is in the TRIPS agreement and one of the WTO agreement, which provides minimum standards of intellectual property, but not uniform. Each and every WTO members, presently 164 World Trade Organization members have intellectual property laws in their domestic countries. They have to follow the minimum standards prescribed by this WTO agreement, which is known as the trade related aspects of intellectual property rights and known as TRIPS agreement, popularly known as the TRIPS agreement. And the nature, which we already discussed, that the nature of intellectual property is definitely it is a human creation of intellect. It is an intangible property. Earlier, every company is survived with tangible properties, but now every knowledge based companies survive with intangible properties. It is an exclusive right given to the inventor or the innovator or the artist or the writer or the author for a limited period of time. Under the TRIPS agreement, presently it is a uniform protection given to patents, especially the 20 years. This is very simple, because the objective of giving this limited period of protection is that after this particular period of time, everybody, the public, would be able to use this particular technology or this innovation. So, the exclusive right is given to the inventor for a limited period of time, for it is an exclusionary use. So, intellectual property is there are a lot of definitions for intellectual property, but it is a clearly which says that we can say that it is the application someone used their mind or intellect to create something new. And we will see later on discuss what are the requirements of these criteria of intellectual property, but it is very clear it is the invention which is mostly appreciated under the intellectual property law, and it is a legal protection. Now, it is the obligation of every country to provide legal protection under the TRIPS agreement to this kind of innovations and inventions. So, if we look into the history, we can see that the concept of intellectual property is not new at all, and we can find prolific inventors in the past centuries. And one of such bright mind is none other than the Thomas Alva Edison, who contributed thousands of inventions, thousands of patents to the knowledge. And you can find his one of the inventions, some of the inventions which is still it is relevant, especially in the case of lights and other machineries. The purpose is very simple of intellectual property law. It is actually a reward or an incentive to the author. It is an incentive to the sweat of the inventor to do more and more innovations in the future. It is a stimulation to the artist. It is an incentive to the writer or the author. So, it is a recognition of scientific creativity. So, that is why we can find number of innovations in the market now. Now, the entire society is run on innovations. So, if each and every company, if you do not innovate, you perish. That is the present situation of the knowledge based companies. So, the rationale is very simple, which we talked about is one is the incentive theory, incentive for creativity, and other one which we can see that this is it is a monopoly right, limited monopoly right granted to people, those who innovate. This is an incentive for further innovation to the society. And there are criticisms also of the protection of intellectual property. They say that each and every knowledge belongs to the society. So, nobody can make it monopoly rights. But in protection of intellectual property also, which is contributing to the society, because this monopoly right is granted to a limited period of time, and also the society what it gets out of it, and the inventor discloses this particular innovation to the society from the day one, so that the limited period of protection is over, the society can use this particular knowledge for further innovation. And if you look into the Indian scenario, so we will come later on, but at a glance you can see India has complied with the TRIPS agreement and enacted or amended its laws in accordance with the obligations under the TRIPS agreement. So, we have Patent Act, we have Copyright Act, we have Designs Act, we have Trademarks Act, we have Geographical Indications of Goods Registration and Protection Act 1999, Semiconductor Integrated Circuits Layout Designs Act 2000, the Protection of Plant Varieties and Farmers Rights Act 2001. So, most of these acts came after the TRIPS agreement, that is came to existence in 1995. We amended our laws in accordance with it. So, the pertinent question is that why should you protect the intellectual property? Why should you protect intellectual property? So, I will give you some of the examples of, I will not say biopiracy, it is theft of our intellectual property. And one is the Basmati case, and other one is Haldi, and the third case is Neem case. So, the Basmati case is simple, and Basmati is a rice which is grown in many parts of India, especially some of the northern states of India, and it have a huge export market all over the world, and Pakistan is also claiming that the Basmati rice belongs to them as well. So, apart from the conflict or the conflict of interest between India and Pakistan, and one of the American company, Rice Tech, in 1997, they filed a number of patents with the US Patent Office based on the biogenes taken from the original Indian Basmati rice, and they want to patent it in the name of many names, and some of them were Kasmadi, Taxmadi, etc. So, it is nothing but the theft of Indian knowledge. It's India's intellectual property which will come under one of the categories of intellectual property, that is the geographical indication. And this company was trying to patent it in the US, and the government of India has to fight the case in the United States, and finally, the US Patent Office revoked it. And the second case is on haldi, and haldi everybody knows that its medicinal qualities of haldi, and its wound healing, especially the wound healing qualities of the haldi. And in 1995, another the US Patent Office has granted a patent for the use of turmeric in wound healing. So, again we saw this Indian traditional knowledge, has been stolen by these US companies. Then again India has to fight this case in the US courts, and finally, this patent also was revoked. And the third case is on neem, and we know that the neem is used by Indians for many medicinal purposes for time immemorial period. And here also we can see another the US company W.R. Case, they want to actually patent different products of neem involving neem and to make a monopoly for them. In 1985 onwards, you can find a number of patents that is a neem based products like toothpaste and other products, and where the patents were filed in the US PTO as well as in the Japanese Patent Office. In 1992, the W.R. Grace, this particular company, come out with a emulsion of pesticide emulsion based on the neem products. And once they made this particular, they patented this particular product, and they are started suing the Indian firms, those who are making this emulsion using the neem seeds, specifically the neem seeds. So, because everybody knows that the bio pesticides can be made from neem, and this is this particular knowledge is in India for a time immemorial period. So, India has to fight this case as well, and in not only in US, in other jurisdictions as well. And in 1997, this patent was rejected, and also in other jurisdictions like Germany is also the European Patent Office has accepted the arguments of Indian scientists that this particular knowledge exists for time immemorial period and in India, and Indian knows this particular knowledge. So, what does it mean? All these cases is what it is specifically mean by these fighting all these cases. So, if you do not protect your intellectual property, not only somebody is going to take away your intellectual property, but also they are going to make it their own and make money out of this, and the patent protection on it, and they are going to have a monopoly right over your intellectual property. So, it is now your duty to protect your intellectual property. When you look into the different types of intellectual property, which I have already explained to you. So, under the TRIPS agreement, there are 7 categories of intellectual property which is mentioned in the TRIPS agreement, and starting with patents, then you can find copyright, then trademark, geographical indications, then integrate layout designs, industrial designs, and then finally, the trade secrets or undisclosed information.